Okay, welcome everyone. This is the specially set Friday, September 1st meeting of the California State Bar Committee of Bar Examiners. I'm Paul Kramer. I'm pretty sure this will be the last meeting I'll be chairing. And I do not have a video feed for this meeting because I am on a bicycle tour of the West Coast, and so I'm traveling with minimal technology. And a camera was one of the things that didn't make it. So with that, I'll welcome everyone and call for the taking of the roll.
Dr. Bolton,
Here.
Robert Brody, Dr. Cow,
Here.
Alex Chan,
Present.
Jim Efting,
Here.
Kareem Gangora, Larry Kaplan,
Here.
Paul Kramer,
Here.
Alex Lawrence, Esther Lynn, Bethany Peak,
Here.
Ashley Silva Guzman, here, Vince Reyes, David Torres. We have a quorum.
Okay. The first item of business is public comment. And the Board of Trustees has adopted a public comment policy which applies to all bar committees, including this one. Its policy statement says the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide variety of viewpoints that reflect the diversity of California. These public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct business on behalf of the people of California in a timely fashion. Written public comments could be submitted to the email address on the meeting agenda. We encourage you to submit written public comments at least 24 hours prior to the start of the meeting. If they're received less than 24 hours prior, they will be distributed the following business day. Written materials brought to that's irrelevant. For oral public comment, persons were encouraged to sign up to speak in advance of the meeting, and they'll be called in the order that they signed up. Persons attending remotely will be called in the order that they appear in the attendee list on Zoom. The speakers cannot cede their time to another speaker, and it is not guaranteed that all who wish to speak will be able to do so. To facilitate hearing from as many people as possible, we encourage you not to repeat points that were made by previous speakers. Simply indicate that you agree with them. To allow the committee the time needed to deliberate on the important topic before us today, we will be limiting comments to 3 minutes per person. If you're on Zoom and you want to speak, you'll need to raise your hand unless you're already on the sign-up list. To do so, you click on the hand icon at the bottom center of your Zoom window. If you're participating via phone, you may virtually raise your hand by pressing *9. That's the star key and then the number 9. And you would unraise your hand by pressing that again. Our coordinator will call members of the public, starting with the pre-meeting signups, then the Zoom list in the order that they signed up or raised their hands. Staff will enable the microphone of the speaker and start our on-screen timer when you begin to speak. If you cannot see the timer and you want us to tell you when you have 30 seconds remaining, just let us know when you begin. Devin, do you want to call the commenters?
Our first public comment will be from Benjamin Cohn.
Hello, thank you. I wanted to express my support for the alternative pathways to licensure in general. I have not had an opportunity to review in detail the full set of implementation parameters behind a portfolio bar exam in the agenda item, but I think in general this could be a good option to look into, especially as the budgetary constraints lead to exploration of whether the current traditional design of the exam is a sustainable, cost feasible pathway to licensure. I see that the crafters of the proposal believe or pitch that the standard conditions of a portfolio bar exam will not need testing accommodation review or provision as much as, I'm not clear on whether they mean at all or as much as the current bar exam, but I would caution against assuming that testing accommodations won't be needed or disability accommodations won't be needed on a portfolio exam, because just because the standard conditions mean that they're needed less often or that the disability limitations come up less doesn't mean that there shouldn't be a robust process in place for when there is such an unanticipated or anticipated need. And if someone's not able to get a supervisor in the portfolio bar exam, they may have to take the traditional bar exam. So the existence of the portfolio bar exam should not be seen as an excuse for why there does not need to be better reforms than those proposed for the traditional bar exam. And those should still be looked at just as closely as if it was the sole pathway to licensure. Thank you.
Thank you. Our next public comment will be from Reverend Frank.
Good afternoon. I'm glad to see Leah's here because she's got some questions I hope she can answer today. Leah, about 2 weeks ago, I notified you were missing 10 bar meeting recordings that all revolve around your return as the executive director. Have you opened up any kind of an investigation to find out how those meetings are missing? I see Leah likes to stay mute, which means she probably is not having an answer. I've also sent out the Freedom of Information Act request again, Leah. I formalized it into a lawsuit. I'll be finishing it up over the weekend, but what do you think is going to happen when I get to file that thing? Why aren't you answering about what's going on with those missing meetings? Don't you think that people deserve to know why those 10 meetings are missing? Folks, if you don't know what I'm talking about, go to the trustee meetings. And in 2020, you'll see 9 meetings listed. And yet when you check the recordings, you won't find a single meeting listed in the recordings for the replacement for Leah after she quit. First one in 2021 is missing. And I've seen them do restore after restore after restore, and they come back duplicated, which is what I can show on my screenshots. And they redo the index and only things left. So Leah, can you explain that at all? What's going on? Have you notified the Supreme Court? Have you told anybody that these meetings are missing, that you can't prove you had a quorum?
Let me ask counsel if we should be discussing this item, which is not on the agenda.
Well, you got to discuss it because I get public comments. And if Leah hasn't opened up an investigation, that should really tell you that she's got something to hide. I think
Mr. Chair,
meetings.
Mr. Chair, he's allowed to make his public comments, but we don't need to respond at this time.
Yeah, that's all I was getting to.
So thank you. I mean, Leah, if you can't find those 10 meetings, what are you going to do? I mean, it makes your return to the bar look like the absolute joke that it is. So no comment, no response. Can't even tell us if you've opened up a investigation.
Well, this isn't the forum to have a discussion today. We thank you for your comments.
That, but she needs to come forward with where this is. She's all for open answers, but yet when she...
Our next public comment is from Ray Hayden.
Viviana has a tiny timer. All right, I have 101 degree temperature, so I'll try to bang out this pretty quick. Hello, Ray Hayden here, and I hope that you all saw the short introduction of my proposal for an alternative pathway to admissions. This is not 114 pages long. It is 1 page, maybe 2. That's it. Why? Because it's a simple program. It's not going to be, if it's not a simple program, it's not going to be manageable. And previous meetings make this abundantly clear. In the COAF meeting, Ryan Harrison called the portfolio bar exam indentured servitude, and another member of the Council on Access and Fairness stated, quote, "I don't remember most of the things I crammed for in preparation for the bar exam. In fact, not one single question, complaint, or inquiry into all of the other programs, none of which had been approved by the very blue ribbon commission established to investigate potential opportunity for alternative pathway to admission to the profession of law, can touch my submission. While the current bar exam is the practice of intentional negligence, I'll let that sink in. Even that is a simple program to manage. The problem is that it costs too much. And if you raise my rates one more penny, you're fired. I already had exams off Botch My Files, not once, but twice. And in July 2021, CalBAR gave my money back, something nobody ever does. The difference between all other programs and my pathway to admission to the profession of law is that my program offers study material to either be created or acquired by the California Bar, plus quizzes and an exam for each subject. And I can help you acquire stuff for free, but through your network. No mandatory subject is rotated around like the normal bar exam. All mandatory subjects are included every single time. This pivotal statement is where the rubber meets the road. The profession of law has been begging for this sort of thing for more than 20 years now, and I know it because I witness it in my business of litigation support, video production, and presentation. I have a lot of time in court, folks. The key point in time for my program is when an applicant qualifies to sit for the current bar exam. At that point, all of us are good to go in this program. You met all the requirements to take the exam, you can do this. My program saves CalBAR millions and millions of dollars from day one. Allows for a reduction of fees to applicants while still allowing CalBAR to fully fund or better their duties and responsibilities in the admissions department. Now, just three last things in relation to the PBE thing. Ryan Harrison said, the more I think about it, the more concerns I have. He called it a hookup for people with connections. I tend to agree, but I still think anything's better than nothing. The bar exam, another member said, the bar exam as it currently is doesn't assess what I think we all know is necessary for practice. By the way, the regular bar exam ends July 27th. Here, the NCBE no longer supports the MBE in favor of the next gen bar exam. So the MBE is worthless. Thank you very much for your time. Have a great meeting.
Thank you.
And feel better.
We do not have any additional public comment.
Okay, let's go on to the only item for the day then, which is, let me get to my outline. Action and discussion on recommendations related to the Alternative Pathway Working Group's proposal to develop a portfolio bar examination. Who's presenting?
So we are promoting right now Jackie Gardina, Susan Bakshin, and Mylan Spencer from the working group that developed the proposal, and they have a slideshow that they're going to share. I believe Susan's going to do the driving.
Welcome all.
Thank you for having us, especially on a holiday weekend, on Friday afternoon on a holiday weekend. So appreciate your time.
Are the slides showing, Audrey? Are we good?
I'm muted. Yes, you're good.
All right. Let me begin by just giving the quick overview of a summary of the portfolio bar exam proposal that you have a draft report for. We are going to assume today that you've had an opportunity to read the proposal or that you will do so in full. And so today's presentation is designed to be an overview and a highlight of the contents of the draft, which is outlined here on the slide, including the request for the proposal from the Board of Trustees, the highlights of the portfolio bar exam description, a summary of its protections and advantages, and a brief mention of implementation steps and timing.
So I'm going to take it from here. I do want to mention that Mylan Spencer is with Susan and I. She wasn't sure she was going to be able to make it today, so she'll be here for the question and answer period, but Susan and I will be primarily providing the overview. The other thing I want to make a point of is while we cover the report, to the extent we offer any of our own insights or opinions, we're speaking for ourselves, not for the working group as a whole. And so I want to the extent you want answers to specific questions that are substantive, it's in the proposal, and we'll try to stick with that. The first thing I want to do is talk about the process that we've gone through.
Sorry, my apologies. Let
Yeah.
me put that
Uh,
back.
The process that we've gone through. So as many of you know, and I believe Alex Chan knows very well, that the BRC, the Blue Ribbon Commission, went through a 2-year process in which they considered an alternative pathway to licensure as one of the options that they were going to recommend to the Board of Trustees and the Supreme Court of California. While there was consensus about recommending a California-specific bar exam, the committee could not reach a consensus around an alternative pathway to licensure. The subcommittee on alternative pathway to licensure did recommend a pathway alternative to the full Blue Ribbon Commission. And the full Blue Ribbon Commission did look at several alternatives, all laid out in the BRC report. Unfortunately, there was no consensus. There was a motion to recommend exploration of an alternative pathway that was voted down. There was a motion to not adopt an alternative pathway that was voted down. There was a motion to delay consideration of an alternative pathway that was voted down. And there was a motion to halt all consideration of an alternative pathway that was also voted down. So there was literally no recommendation from the BRC regarding an alternative pathway. As you know, the Blue Ribbon Commission's recommendations went to the full Board of Trustees in May, and the full Board of Trustees passed those recommendations on to the Supreme Court of California intact. Separately, in a motion, the Board of Trustees did request to hear from those who support an alternative pathway and ask for a draft proposal to be submitted no later than their September board meeting. As a result of that, several members of the BRC volunteered to start working on an alternative proposal. And we started meeting on June 6th. And the full BRC received an email on, I think, May 23rd or May 26th regarding the Alternative Pathway Working Group. And then the working group began its work on June 6th. There are 5 of us in that working group. Susan, Judge Glenn Reeser, Dean Natalie Rodriguez, and Professor Mylan Spencer. And over the course of the summer, we met every week. And we actually met with psychometricians, and this is all spelled out in the report, 3 psychometricians, 2 who were unrelated to the Blue Ribbon Commission's work, and then Jim Henderson, who was involved in CAPA and the BRC, agreed to come and speak with us as well, although he was not part of the working group itself. And we also were able to use all of the material that the BRC had, as well as delve into new material that was coming out of Oregon and some of the other states that are considering an alternative pathway. After the draft report was completed, we then submitted it to all of the Blue Ribbon Commission members to give them an opportunity to provide us feedback. COAF also received a copy of that report, and we met with the Council on Access and Fairness on Friday. And then I'm very thankful that we also had the opportunity to meet with members of the Committee of Bar Examiners today. And then the final proposal will be submitted to the State Bar next week with final consideration by the Board of Trustees in September. Next slide.
All right, next up, we want to give a brief overview or summary of the portfolio bar exam and describe its components briefly. Again, there's much more detail in the draft report itself, but what we have is a 2-fold requirement of both supervised practice and portfolio assessment. The supervised practice will be 750 to 1,000 hours. It will start after graduation and is designed to end mid-November to line up with examination practices. We will use trained California attorneys as supervisors, and we are recommending an independent evaluation by the licensing agency, meaning the supervisor is not the ultimate arbiter of the portfolio and its appropriateness. The portfolio requirements are going to demonstrate both skills and substantive knowledge of an entry-level attorney by submitting multiple items that meet itemized criteria. We also have recommended that the portfolio bar examination require completion of certain law school courses in the core subjects as outlined by the CAPA report you may be familiar with, that will establish those foundational entry-level practices to ensure breadth of knowledge. And finally, the portfolio requirements will also include a variety of things such as professional responsibility analysis, negotiation, client encounters, and more. The actual components that we have recommended for the portfolio bar examination are itemized at some length, including each component and its rationale in section 4, subpoint 9, that's section 4, subpoint 9 in the draft that you've been provided. I'm staying away from page numbers because it does matter whether you're using an electronic or printed version. But if you go to section 4.9, you will find a detailed chart with the portfolio requirements outlining both their content and their rationale.
And I would just add to that, Susan, that again, these are just a recommendation and a framework or a starting place for what we hope will be subsequent work to finalize a project like this. So please see these as a starting place, not an ending place. So next we want to talk about protection and advantages. So one of the things that I think is of utmost concern is the idea of whether or not we can create a fair, reliable, and a valid result, which is why we brought in 2 outside psychometricians to talk to us. Both of them have been involved in psychometric analysis, both in portfolio or in non-traditional settings, so that they could provide us feedback about what's possible and what are tripwires we need to watch out for. We found that while it may be challenging to create the rubrics and the standardization, it's absolutely possible. And as you can see from the report itself, the psychometrician supported the concept. We allowed both psychometricians that are quoted in there to review the draft report in advance to make sure that we were citing their work and their beliefs properly. And we got great feedback from them on the draft proposal as well to make sure that we were responding to everything as it was said. Obviously, you can't just jump into a supervised practice pathway with a portfolio-based exam. There needs to be rubrics created. There needs to be calibration, just like with the grading of the bar exam. And there needs to be some pilot testing of that. So all of that would be necessary as a first step in moving forward with any portfolio-based exam. What are the advantages, at least as far as the working group feels? And I think I can speak for the working group when I say we actually believe that a portfolio-based exam and the components we've identified in the draft proposal is a more comprehensive way to assess minimum competency. As we know, the exam, the traditional 2-day bar exam is limited in what it can test as it relates to skills, and perhaps is a little bit too broad as it relates to knowledge. And so we believe that this is a better reflection of what it takes to have minimal competency at the entry level. The exam is more of a proxy for knowledge and skills, but the portfolio-based exam will actually be a direct assessment of knowledge and skills. The other thing, and I heard a public commenter say, let's put an asterisk next to this, which is that the portfolio-based exam is universal design. Universal design meaning that while because it reflects the realities of practice and will be created in the context of practice, the State Bar itself doesn't have to provide accommodations or manage that as it would in a standardized testing environment. Obviously, anyone who has a disability may need to seek job accommodations, but they won't have to necessarily get that through the State Bar of California. And I know that's been an issue. So the bar exam will the portfolio bar exam will reflect the realities of what's necessary for each person to practice regardless of abilities. and we think will go a long way in being more welcoming to people of different abilities. We've also identified some protections for applicants. I know one of the big concerns that came out of the BRC, it was mentioned in Alex Chan's dissent that the full CBE ended up kind of adopting and putting forth to the Board of Trustees, was a concern about discrimination. And a lot of that came largely from the Ontario study. We did take a look at the Ontario study, and we do acknowledge that what emerged from that was troubling. 21% of the respondents who had completed articling reported facing some kind of conduct or comments that were about a protected personal characteristic. But it's not really clear to us how much weight we should give to these survey results. The psychometrician who reported the results warned that the survey's response rate was really too low to generate reliable findings. Importantly, the Canadian article system has a distinctive culture rooted in the historic scarcity of articling positions. Until recently, the provinces required all candidates to article for at least 8 months, creating a high demand for articling supervisors and making candidates highly dependent on their supervisors. And the portfolio-based exam isn't going to suffer from that both culture and history of scarcity of positions in the same way. So we thought it was actually more beneficial to look at potential discrimination or harassment in the context of California's portfolio-based exam by actually looking at the provisional licensed lawyer survey that was provided to those in the original provisional licensing program, as well as those in the pathway program. So there's about 1,600 provisionally licensed attorneys that were part of that. And the response rate was over 40%, which is quite good for any survey. And we found different results than those in Ontario. And while it's not, unfortunately, not unheard of or uncommon for people to face discrimination and bias in the workplace, we hope that we've identified some protections that can be put in place to mitigate those concerns in this particular context. And again, this is a framework, a starting place. It's not the end result. One is that individuals aren't required to complete all of their hours with one supervisor. And that way, if there are feelings of discontent with a supervisor, there is an opportunity to move. The other is that the supervisor is not responsible for assessing their work and determining whether or not they should be licensed. It's going to be an independent assessment of their work by anonymous and by outside graders. And so that should also relieve some of the burden. We also know that there is an opportunity to create an ombudsman or other position that could help at least have a place for provisionally licensed individuals to go. And I think there's other protections that could be put in place as well. So we tried to speak to that in our final report and also create some mitigating effects in there. I think that we also spoke in our report to the increased access to an affordable exam option. One of the things that we know is not just the cost to the State Bar of California for the bar exam, but the cost to the individual applicants. And the cost isn't just the cost to take the bar exam and the costs associated with that, such as the bar exam, review course, the travel, and the hotel. But there's also lost wages for those who don't work for 8 to 10 weeks as they wait and study for the bar, as well as those who wait another 6 months to find out whether or not they've passed and then potentially discover that they have it. In the portfolio-based exam, we are recommending that all applicants get paid at least a minimum compensation that equals the amount that any new law school graduate might be paid who doesn't yet have a license. And we certainly found in the survey with the PLLs that that was the norm. And so we would encourage that to be part of the recommendation itself. Susan, do you have anything to add to this?
No, I think one of the things I would just would add would be just the generic statement that there is a lot more detail on each of these particular topics, and it's addressed more fully in the draft itself. But what we wanted to do today was highlight the key features and advantages, and to highlight some of the protections that have been built in, because we did decide not to adopt an Ontario articling method, but to put forth a portfolio bar examination instead. These types of more comprehensive choices, a portfolio assessment, more comprehensive approaches to licensing, are not a new or radical idea. There's growing interest in other professions, including medicine. There is also more broad interest in these sorts of more comprehensive assessments, both at the K-12, elementary and other levels, but also in higher education. It is becoming more common to use and adopt portfolio types of assessments in both professional licensing and in all matters of assessment. It is a growing and building area. That said, we have a short list here on the slide of the states adopting or considering the more comprehensive methods of assessing minimum competency. Currently, those include Georgia, Minnesota, New Hampshire, Nevada, Oregon, Utah, and Washington. And I would add a particular note about Oregon. Just recently, on August 23rd, they approved their rules for their portfolio assessment for a more comprehensive licensing approach. Their alternative is awaiting federal court approval. They could start their program as early as this year's graduates. So the Oregon model has some recent developments there. But what we do know for California is that there is sufficient experience with psychometricians, with other jurisdictions in the literature. And this is a field that continues to grow. So we feel confident that the portfolio bar assessment can be done and that we will be able to provide that valid and reliable assessment. We also have in our draft for the portfolio bar exam some materials on the pilot process and scaling. I am not a psychometrician, so I will not attempt to summarize the psychometrician experts, but they have assured us that we can use a pilot system to approve the rubrics, and that this would be an opportunity to create them and to vet them, and that the assessment of about 100 participants, which we could use from the PLL program. There are about 100 participants in the provisionally licensed lawyer program that would potentially be available for a pilot. That would give us some possible data and results that would let us see if the protections that we have outlined need to be evaluated, changed, or modified in any way. And we would also, of course, be able to vet and create and approve those grading rubrics. We also have some materials in the full draft about scaling. Again, it is an initial framework. The Board of Trustees invited this group of volunteers to put forth a proposal, a framework. We have not outlined every detail of a final program, but we do have some information in the draft if you're interested in seeing how we might pilot this with the provisionally licensed lawyers as a starting place, and how some legal services organizations have expressed support for some initial funding for both the pilot and setup of the program. So I would commend you again to the draft itself for more information and details on these, but this is our sort of overall content of our draft.
So just to summarize, at least for the working group, we believe the portfolio-based bar exam actually removes some of the artificial barriers to entry while actually providing for increased public protection. There's universal design. It levels the playing field for those without economic resources or with fewer economic resources. And we also like the idea that it provides access to options. Someone can take the traditional bar exam, or someone can enter the portfolio-based exam. In terms of the alternative pathway. Again, supervised work, at least our recommendation is 750 to 1,000 hours plus an independent evaluation of the portfolio. We tried to align it with the timing of bar exam results as well, so that individuals would be getting their portfolio-based bar exam results at the same time or around the same time, if not earlier, than the bar exam, traditional bar exam results are issued. We've also recommended to the state bar that there be no indication on the public website, the pathway that was chosen by the individual, but just that they passed a bar exam. And really, we believe that you only will earn a license if you demonstrate that foundational knowledge and skills that entry-level attorneys must possess. And in some ways, the demands of the portfolio grading system may be higher and more rigorous because it's in a setting in which memorization of rules is not required, but it's really about application and client protection. So I want to pass it to Susan and Mylin for any final words before we open it up for questions and comments.
I think I would just add a simple comment that one of the things that is, I would emphasize is our final point here, that the exam tests by proxy readiness for practice of law and whether licensees have demonstrated that foundational knowledge and skills that are necessary for entry-level practice, and that this would provide an option that actually directly assesses that knowledge and those skills. And that, again, to emphasize, of course, that this would be an option and that our draft is a framework design to begin the process. And that there would, of course, be data collection and assessment and refinement of the details.
Mylin?
I would just add that I'm really, this has been a lot of work over this summer, and I have been happy to do it. I'm really excited about the proposal as a clinical law professor who both teaches in the doctrinal world and teaches a clinic. I feel convinced that this is the best way to ensure that we have a competent bar where we're teaching and assessing the skills that lawyers need, rather than doing what I spend a lot of my day doing these days, teaching students how to pass an exam that doesn't really test their ability to practice. So I look forward to any questions that you may have for us.
Okay, can you take down the presentation so I can see the raise their hands up? Make my list bigger. Any questions? There must be somebody. If not, I've always have some, as you know. Speak up. All right, well, I'll get the ball rolling. So this notion that you could time the results of a portfolio pathway to match the November results from the bar exam, that is cramming those 750, or if it's 1,000 hours, that's a half a year of work, plus the time that's needed to grade. So that just doesn't seem possible when I do the math. It seems like it's gonna, and also how important is that really? Because depending on how we try to resource this, if we're asked to, we may want to use much of the same staff for efficiency reasons, and increasing the workload from both the regular bar exam and this program, at a particular time works against that, if you know what I mean.
Yeah, thank you, Paul. I think those are both good points. I think part of it is that we start counting from, let's assume, a May graduation date. Different people finish law school at different times in the spring, so it could even start earlier. And that's 6 to 7 months to complete that. Certainly not everyone would complete it within that time, especially those who might have to maintain other work or family life schedules. And there's also the possibility that the portfolio isn't approved the first time through. The reason why we felt it was important to try to align it, although your resource question is a very good one, is that there was some concern expressed by people about the potential for a two-tiered system based on what pathway you went through. And we're happy to speak more fully to that because I think it's come up a couple of times, but that's what the alignment was intended to do, as well as not to penalize someone if they entered one pathway or the other in terms of the amount of time it took to actually achieve licensure.
We were in hopes that by creating an option that permitted people to finish on the same time frame as the exam, that keeps things in parity and makes the options both attractive. To your resource question as well, we have also discussed in the working group the possibility that grading for the portfolio may be able to be done in a different manner than the examination. The examination is all items arriving at the same time. And with the portfolio, we are very likely to have applicants submitting on a variety of timeframes and that grading burden to be spread over a much greater amount of time, so that graders would not have all of the exams or all of the items at one time the way they have all of the exams at one time. So that may in fact make it that the resource issue is actually a little bit better and could eventually be spread over an entire calendar year.
Okay, Ashley?
Yeah, I had two questions. So one was about one of my concerns was actually addressed in the document, but it talks about when students or post-bars are submitting their packet and the level of review that is going into those documents that they're submitting by a senior attorney or by a partner, whoever's reviewing those documents. So it talks about kind of the similar submission of the templates or any template bases that they're using. I think it's similar to what Oregon does. So with that submission of templates, do we see any issues with firms wanting to provide those templates, or do we think that it's kind of a matter of they know that's what they're getting into and it's not going to prevent a student from being able to submit those templates?
The templates that we talk about with the portfolio bar examination are a recognition that a great deal of lawyers' work, particularly, for example, transactional work, involves using a form book, not provided by a law firm, but provided by a legal publisher. And that perhaps many people use those documents as starting places appropriately for drafting documents. And so there is in the portfolio, again, I would recommend you to the document, as you noted, it is in section 4.9, a detailed chart, which goes through those components. And also around that same area is a description of the cover sheet that would require disclosure, so that a student would not simply be able to submit a template document, that they will in fact have to put a cover sheet on it that explains how they've modified that template and why, and the legal work and analysis that went into the creation of the final document and where their work product is. We will also require the supervisor to attest that it is in fact sufficiently the applicant's work.
Gotcha. And then second question is regarding, and maybe I missed this, but is there going to be a process built in for applicants to submit complaints about issues that they're facing in the workplace, or is that something that the expectation is that the bar will field those complaints, or would it go through kind of a general attorney misconduct complaint process in kind of the ideal view of it?
Yes, so as I mentioned, I welcome Mylin and Susan jumping in on this as well. At least for purposes of this draft proposal, we suggested an ombudsperson to be a point of contact for any bar applicant who might be struggling in a supervisor relationship or having other issues within the workplace. But I'm sure that there's other alternatives that can be put in place as well to protect the applicants in these situations. And Mylin and Susan, happy to have you chime in.
I'm going to pronounce it incorrectly, but it's Enrique, I think it's Zuniga's office as ombudsman today. His role is public facing for public complaints. But his role also includes all aspects of the administration and application. So the application process. So to a certain extent, I think some of your concerns, if an applicant did have concerns, they would have the already existing new office of ombudsman at the state bar that is already in place and designed to include at least some of those requirements. I suspect that some of those complaints would depend a great deal on the specificity of the individual complaint and where it might be properly taken. One of the things that we do know from the provisional licensing lawyer data is that provisionally licensed lawyers were highly successful and were well received by their clients. They did not create a plethora of attorney-client complaints, and supervisors were very, very satisfied with their work, and so were clients.
Great, thank you. And sorry, just a quick follow-up for that. Do we think that, I know that this is just kind of the beginning phases of anything that could potentially come up, but do we think that the ombudsperson would eventually run out of capacity to field anything, or is it such a small number and the anticipation is that it'll remain a small number that we might not need to expand that role?
There are more details about scaling in the report itself, but partially I don't believe there's an initial problem at all. My personal assessment would be in a pilot of about 100 people, we will not have a problem. And the PLL data, I think, gives us a lot of confidence that we would not have a problem even scaling it 10 times that. And I think that one of the things that the benefit of a framework as a starting place is that ability to scale as you go. And, to the extent the ombudsman's office required additional resources or assistance, that would definitely be something that would be assessed in the pilot data.
And actually, if I can speak to that as well, I think some of these concerns came up on the Council on Access and Fairness as well. And there's a lot we don't know. We have the PLL as a starting place and the survey as a starting place. But obviously, our recommendation would include a continued kind of study and understanding on a longitudinal level about the bias and discrimination faced, not just in any alternative pathway, but also through the other bar exam pathway as well. Because I don't know whether it would be fair to say X person experienced discrimination within the portfolio pathway and not also study whether or not someone was facing discrimination within their law clerk pathway, even though they had sat for the bar exam. So I think it's important that it not be hyper-focused, but rather seen across the spectrum. And then I think disaggregated to see if it's more prevalent within those who went through the pathway program. I think the other thing the working group thought about was because those in the PLL, even those who identified facing bias or discrimination within their experience, also spoke incredibly highly of the provisional licensing program. We felt it was a bit paternalistic to say we're going to protect them by not giving them this option, even though they felt as if they had a really positive experience despite some of those bad experiences within the context itself. So absolutely it could happen and it needs to be solved for, but we decided not to try to protect everyone.
Right. Thank you.
Larry?
Thank you. I don't have any questions. I just have a comment. I don't know if this is the time to make it. I think this is an excellent idea that we certainly need to pursue. And I'll tell you what I'm thinking. I mean, obviously, there's a lot of things that need to be figured out, like, the sort of the transparency and independence of judging whether or not somebody has, quote, passed muster. You can't just rely on their sponsor or whatever you're calling the person that they're apprentice to. And there's a whole, and plus, the issues that Ashley brought up also in terms of potential for discrimination. But the thing that I really like about this is anyone who has been in the business world or anything, any world, academics, whatever, for more than 2 weeks knows that subject matter knowledge is great, but knowledge of people and how to manage and engage in and manage relationships is critical. And that's what this pathway does that the exam does not do. You know, exam, you're great at taking the test. You studied hard, you know all the facts, you're a savant, you're an idiot savant. Okay, but the proof and the sign of a good lawyer is somebody who not only knows the law and knows the process, but also knows people. And that's what I like about this. So that's my 2 cents.
Could I just jump in and respond to, it didn't sound like there was a question there, but I for one really appreciated your thoughts, and agree it's an excellent idea to pursue. I just want to be super clear about how the assessment process works, because I'm not sure we totally answered one of your questions, Ashley. When a candidate submits a portfolio item, for example, one of their written pieces, and they use a template that their firm provided, that assessment goes to an independent assessor. It's not their supervisor who's doing the assessment, right? So it's not their, you mentioned Larry's sponsor. It's not their sponsor. It's an independent assessor who's reading an anonymous piece of work that has been sanitized, so there's no identifying client information in it. And then that person decides whether it's competent or the item shows competency or not, using a rubric. And that doesn't go anywhere. The template that's used, it remains private within that assessment. So I just wanted to be super concrete about how that's happening to protect the client. And you bring up a great point, Ashley, to kind of protect work product of the firm. So theoretically, they shouldn't worry about having, they shouldn't have any security concerns about their work product.
Bethany?
Thanks. Thank you all for this presentation. This has been extremely informative. So I'm going to the supervising attorney matter. Before I ask my question, I just wanted to clarify the way that an applicant would find their supervising attorney is just by what? They would be out there as if they were looking for a job. Like, where would they find these supervising attorneys?
There's a variety of models that are potential here, and we have outlined some frameworks in the draft, but to give you an idea, some perhaps just the way you suggest. They are otherwise looking for a job and that employer is willing to supervise them. So it can be part of perhaps career services at a law school. It can also be their own job efforts. It can also be through other means. We do have legal services organizations that are interested in providing support. They have existing frameworks of supervisors. Many federal government offices have existing frameworks of supervision. For example, the IRS supervises its attorneys in an existing system that this is basically a seamless entry into. And so there are a variety of both public and private ways that a person might find a supervisor. Eventually, we anticipate that law schools would also use their alumni networks to provide. But again, we go back to the PLL data and we find that supervisors were available to applicants in an emergency, in a pandemic, with no warning, and they were able to find them. So we know that there is the potential to expand and improve that access and to ensure that more folks who are interested in this particular path would be able to actually secure a supervisor that was appropriate for them.
Okay, thanks for that. Then my question is just, I'm wondering regarding, I think it was in public comment, someone had raised the concern about like this being a way for people that have connections with lawyers to be able to essentially, I think they were insinuating, have an easier pathway to licensure. And I do wonder, are there any kind of safeguards in place, or has it been considered about ensuring that people are not using close familial relationships or close personal relationships in order to ascertain these supervising attorneys? Because obviously there are communities that have far better access to people that are in the legal profession than others. And I think that that might create some kind of a disparate impact. And so I'm just wondering if that has been thought for and accounted for.
Mylan, do you want to jump in?
Sure, I can speak to that. I mean, one of the parts of our proposal is that the supervisor not be permitted to be a family member. Because there's both the concern of the disparate impact, but also the sort of conflict of interest concern. So there's one structural piece there that we've built into our proposal. Another piece of information, important piece of data goes back to the current PLLs who found supervisors without much trouble at all. And we found there's a pretty comprehensive study on who participated in that and who succeeded in that. And it was, it actually had a beneficial effect in that women of color, men of color, and women all took advantage of, were able to find supervisors, succeed in what is essentially a supervised practice pathway now. So we are expecting that it won't actually have the kind of negative disparate impact that some alluded to earlier.
And I just encourage you to look at the PLL survey numbers themselves, because they do speak of who took advantage of the PLL, both the original program as well as the pathway program, and their challenges or not in finding supervisors. I think I want to speak to the other thing you said, that it would be an easier pathway. I understand that people want to portray it as easier, but one, I don't think that it is. I think it's a better way to assess minimum competence, because it actually relates directly to the work product that you would complete within the context of legal practice. I also think the grading is going to be very different in the context of the rubric. And obviously that's going to be talked about in the development of rubrics and in the grading training. But your expectations, or a grader's expectations, of what a work product needs to look like for minimum competence to be met is going to be different than a grader's expectation for a timed exam where you had to memorize rules and regurgitate them and write the essay in 90 minutes. So I want to make sure that people understand that it's a different assessment model, not an easier assessment model. And in fact, I would argue that from what I hear from those in the practice world, and many of you may have experienced this, new law graduates actually struggle quite a bit with those initial entry-level work that they need to do. So I'm not confident that it's going to be easier at all.
And to bring together both Jackie's comment and Mylan's comment, I would just add that the PLL data, just to summarize it quickly, women of color found supervisors and used the program at the highest rates, followed by men of color and then white women. White men were the least likely to take advantage of the provisional licensing program. So I think that that data gives us at least some preliminary comfort that the structure and the framework we're outlining here would make it possible for there to be access to supervisors. And I think it's important to draw that distinction of, even for those that it might be easier to find a supervisor, the ultimate pathway and the assessment by an independent evaluator of anonymous work is not easier than the exam or than other assessments of proper minimum competency.
Thank you for that. And I apologize. I didn't want to interrupt you, but that's not what I was saying. And so I apologize if I didn't express myself. I was not trying to say that this is an easier way to become a barred attorney. I was trying to say that, to use an example, if I have 8 lawyers in my family, it's far easier for me to be able to source supervisors to participate in the program. That's what I was trying to convey. But you guys have answered my concerns regardless. And so thank you for that.
And we certainly hope that some of those people who have a lot of contacts with a lot of supervisors and lawyers will also take advantage of a portfolio bar assessment.
Bethany, anything else?
No, that's all. Thank you.
Okay, Kareem?
Yes, thank you, Mr. Chair, and thank you all for your presentation. I came in rather late, so I'm kind of catching up. But I did like the comments that Susan provided regarding to the data with the PLL. I'm a huge fan of the program. I've been one of its biggest proponents in capturing its demographic data, and ensuring that we were capturing what was happening with our communities of color. I regularly share I'm in an under-resourced community, and we're extremely disadvantaged. We have issues with having accessible judge, having attorneys, and so I guess my question for the presenters is how does a program like this work in an area like the Inland Empire, where you're just severely under-resourced, and you might not have access to those kind of supervisors that have the how do I say it respectfully, like they don't have the capacity to take on these kind of clients, or I'm trying to find the wording, but basically in my area we just have we're severely under resourced. So give me your response to that kind of situation.
Yeah, and I think, Kareem, what you're talking about is if there's a legal desert and the lawyers that
Yes.
there might be overwhelmed and not able to provide supervision in the ways that one would hope.
Yes, you read my mind. Thank you, Dean Gardina.
Yeah, and I think it's a great question. And one of the things, and Susan and I are actually going to be speaking with the Access to Justice Committee next week about the proposal. And one of the things that they're very interested in is there a way for us to use the program to actually provide services in rural communities? And is there a way for us to try to bridge that access to justice gap while people are doing the work necessary to get a license? So I know legal services organizations, the Access to Justice Committee, and others are very interested in working in tandem with any proposal that the Supreme Court of California ultimately adopts, to see whether or not it can serve both purposes. So I think your point is a really good one, but I don't think that you're going to be working on it alone. And I don't know if Mylin and Susan, you want to speak to that at all.
I think this is like many things where we hope to see that our framework can be expanded and eventually establish solutions for exactly things like areas that are attorney deserts. And I can envision one way here where the choice is more helpful. Just the existence of the portfolio bar examination is better in an area where perhaps there is only one lawyer in a small town. And that lawyer can take on a provisional, take on the recent grad and immediately have help providing services. So yes, there is an obligation to supervise, and everybody does feel stretched and that would be an additional obligation, but it comes with real work being done by this lawyer. So it does provide that person working in the legal desert who takes on a portfolio applicant does get the assistance. And that is something you see a lot in the PLL data and comments from the supervisors, that how good the work was that was done by these applicants with the provisional licenses. And I expect that we would see the same here, and that it could in some ways be easier for those folks who could oversee and yes, have supervisor obligations, but have immediate help and support in their practice where there may not be a lot of that to be had.
And I think the PLP data, when you go and look at it, actually speaks directly to what Susan was talking about. One, that there were people in rural areas, in small and solo practice settings, and that the lawyers who supervised actually experienced a benefit of supervising. It wasn't just about providing supervision of the portfolio or the PLL in that case, but they received a benefit, as did their clients. So I think there's a way for us to work it, but like other things with this framework, it's something that we need to consider and work on.
To provide
It-
one example, the PLL data did include some comments from supervisors that said they were able to expand the types of work they offered in their practice because of the existence of the provisionally licensed lawyer in the office.
And so is there any similar programs throughout the nation that is kind of incorporating this kind of model? Or is this a unique framework that's being developed?
If I believe that Audrey's going to share the slides we shared at the beginning of the presentation, and there is a list there of the states that currently are evaluating more comprehensive models. But just to give you the quick answer is this is becoming increasingly common in other professional licensing, in K-12 education, in higher ed education, and we are very soon about to have even more support and resources able to help us accomplish these types of programs.
Yeah, because I'm seeing a transition to workforce development through apprenticeship, career apprenticeship pathways, and so just kind of understanding it from a high level perspective, it kind of appears to me that way with the licensure component to it. But yeah, those are all my questions. So thank you so much for your feedback. I really appreciate it.
Thank you.
Okay, Esther or Alex, do you, as our representatives to the Blue Ribbon Commission who consider this for much longer than the rest of us, do you have any comments you want to share, either of you?
I certainly have my own comments, but I don't have any questions, Mr. Chair. If you're asking for my comments, I can share my comments, or we can just finish the
oh, okay.
question
Yeah,
section.
and I've got a list too. So maybe let me go to Esther. Did you want to say anything at this point? Okay, let me go to my list. I have a few
Dr. Chow
things.
had his hand raised, but now it's, I just want to make sure we didn't miss.
I don't have any questions.
Okay, I guess I have a couple that.
And Dr. Cow has his hand raised.
Okay, go ahead, Dr. Cow.
Thank you. I had a question. It's a great presentation. So one of the things that you mentioned during the presentation was about independent assessors. And so one of the questions that Kareem had asked was, is this a unique motto, or, and you had mentioned that there's other states that are in the process of evaluating it. Is there a model that already exists on how to independently assess this? Number one. Number two, if there isn't, how would you develop independent assessors? Because it sort of sounds like, well, number one, we have the bar exam, we have to have our graders that we do have a system for. But now if you do a parallel track where you have to have independent assessors, they have to be trained looking at it from a different lens. And so from a scaling standpoint, that means that you have to have an increased pool of graders or assessors, number one. Number two, you have to create a new pathway for people to learn how to assess this, because this is a de novo motto. And then third is that where would you use the template for this? So those are my questions.
I think just to start, we could start with the overview that jurisdictions are in various stages of assessing adoption of various models of more comprehensive assessment. Oregon is probably the furthest along. Their independent assessment is already ongoing and has been for about 6 months. They've done 2 cycles of portfolios already. And Oregon also has, as I believe it's August 23rd, recently approved a set of rules in detail about many aspects of the assessment, the portfolio contents and protections, and a variety of details that is available as a starting place for California to create its own rules and details. But again, much of what you address is very important and will be what the next steps would include, that we have presented a framework and a portfolio with some initial scaling and initial piloting. But there would, of course, need to be more work on all of the things you identify. We do have in mind that the graders will be trained and use a system of calibration, much the same way that essays and performance tests are. Graders are trained and use calibration sessions to ensure that there is the validity and consistency that is critical here. But I do believe that a variety of jurisdictions are in a variety of different places. Oregon, I think, is the furthest, and their rule template would provide you with a lot of good examples. I believe it's cited in, or will be cited in a footnote in our final report with all of the details.
I'd also add that as far as not starting from scratch, in addition to Oregon and perhaps other jurisdictions, we already have some familiarity with how to do this from clinical legal education. I myself have developed rubrics, used rubrics to assess in some detail, probably in much greater detail than would need to be done for this purpose, how, the quality of a negotiation. So there are rubrics that are out there, and there are ways to calibrate assessors that I think we'd take advantage of.
And I think the last thing I would add is both psychometricians that we spoke with, Elizabeth Anderson and Chad Berkendahl, have been involved in assessing portfolios outside of the standardized exam prospect and have written about it. So both of them provided resources and ideas about how best to do this. It is happening in other disciplines, and it's just new to licensing in the legal profession. Did we answer all your questions? Because you had 3. And
Yes, ma'am, you did. Thank you so much.
thank you.
Okay, let's see, a couple of my comments that I've got an outline that I might share later, but that really are questions. With regard to experimenting or testing all this with the people who remain in the provisionally licensed lawyer program, can we consider them a representative sample at this point after so many of the initial members have graduated, if you will, from the program by passing the bar exam, or perhaps just deciding, not to pursue the goal of becoming a lawyer in California? In other words, so if that's not a representative group, what sort of informative conclusions can we draw from that?
The psychometricians we spoke with actually did not express any concerns that the PLL group was insufficient in either size or its representative features.
But did you ask them the specific question that I just did, or?
Well, we met with many people over many meetings, so I'm not going to be able to recall every question we asked every expert, but I do believe that we need a pilot that is both small enough to be manageable and large enough to be representative. The PLL data suggests that it is a representative group when you look at who remains.
Okay. And if portfolio submission is derived from a firm's template, how do we filter out the knowledge and competency that's built into the template and determine whether the applicant has really added anything to that?
So if you look at the proposal, Paul, it requires them not just to submit the final work product, it requires them to submit the template itself and to also describe what changes they made and additions they made, so that they're explicitly calling out what is their work product versus what came from the template. And it could be that an independent assessor decides that's not sufficient.
Okay, yeah, because quite often they might make very few value adds to a good template in a very simple matter.
And that likely would not make it their best choice for a portfolio submission. When you look at the rationales on the chart and the selection of different kinds of activities, applicants will have some level of control over what they choose to submit. And if they've made only minor revisions to a template, that wouldn't be a satisfactory submission.
Okay, let me see what else I have here that's appropriate to be a question. I guess this is a question for staff. Do we have the bandwidth, the resources to be able to support this undertaking along with the existing undertakings to develop a replacement bar exam and to revamp the first year law students examination and probably some other things I'm forgetting at the moment?
Well, part of what you're talking about in terms of the first year law students examination that we talked about last meeting could actually open up bandwidth depending on what we're discussing with that exam at a future meeting. So it's possible that there could be, between all the exams in the wheelhouse of admissions, there could be some redistribution of the workload that could advantage this sort of portfolio bar exam. But the parallel work and the training, I mean, the ramping up of training new graders to do the independent assessment and calibrating work product that is not, when you calibrate the essays now, everyone's answering the same question. So calibration, I'm sure there's a lot of training that would be involved with calibrating work product from different areas and practices and how you calibrate those portfolios against each other. So I imagine there would be a lot of ramp up in terms of the training of how our current grading pool. But I think it would be possible with a small pilot to figure out how we could redistribute the workload. That's my personal opinion.
Okay. So if we get in the business of having two alternative programs for entry into bar membership, that's in my view has to significantly increase our costs for the bar exam itself, because we will have fewer takers over which to spread many of the costs, which are fixed costs, staff, calibrating graders, developing the questions, etc. And in an environment where we are reluctant to fully recover those costs from the examinees, and are appearing to try to seek approval to pass those costs on to all existing bar members, just how is that going to work? That may be a Leah question.
Well, and there would be a application fee for the portfolio bar examination as well. And there was in the proposal a minimum compensation recommended for those in that pathway. But go ahead, Leah.
Right, I don't have a really different answer other than a fee would be assessed and the fees would have to cover the cost of the program.
Yeah, except that's not the way we think about it now.
Well, I think increasingly we are. I expect certainly the board to take action later this month and increase fees related to the bar exam and the first year law students exam and other fees quite significantly. In addition, I believe they'll adopt a policy similar to one they've done on the general fund side for other service fees, saying that we need to adjust the fee annually by at least the CPI. So I think the State Bar as an organization is having to be more fiscally prudent. So I think we're certainly moving in that direction.
Okay, well, I mean, nobody could agree to raise the first year exam fees to what it would take, which was over $3,000. So, I mean, I'm glad to hear we're now thinking that way, but I mean, it's not going to be cheap for anyone. Okay. Let's see. So my final question, I guess, will be, I'm concerned that to say just move this thing forward and recommend it to the court, and that the court come back and say do it, without all the details being worked out and the experience from the trial, will put a thumb on the scale in favor of making this a permanent program, when I think it still at best needs more work, tweaking, and analysis of the pilot results. For the proponents, what are you really expecting from the court? Just marching orders to just go make this thing happen, or do you see it more as a further development and study kind of authorization?
Yeah, in the proposal, we actually talk about the next phase, and the next phase would be a committee, certainly involving psychometric experts to help develop rating rubrics, etc. So there is absolutely more work that needs to be done. The pilot or the case study would allow for those rubrics to be tested to see whether or not they're can actually meet the requirements that are necessary to have that validity, reliability, and fairness that is so important. So I think, Paul, to your point, an enormous amount of work still needs to be done. I can't speak for everyone. I obviously believe in creating an alternative pathway to licensure. So what I wanted from the BRC was the recommendation to explore an alternative pathway. The Board of Trustees obviously gave this working group an opportunity to put forth what an exploration might look like. And it's an opportunity for the Supreme Court, if they so choose, along with the State Bar, to actually explore what an alternative pathway would look like. But certainly it's going to have to go in phases, and it's going to have to be studied, and it's going to have to be adjusted. Any good innovative project has to have an iterative process. So there's no way that it can simply be launched. But we've given you a starting place for exploring what it might look like.
And where does the Committee of Bar Examiners fit into all this? We were kind of shunted to the side, in my view, with the BRC. But do you envision a broader role for the CBE and any future project?
Well, I'm not sure that Jackie and Susan and Mylin are in the best place to answer that question. I think that would be something for the board and or the court in identifying sort of the work stream to identify the how CBE is going to be involved.
And thank you, Donna. And to answer your question directly, Paul, what we expect from the Supreme Court is that the court will make its own decisions about the best way forward for licensing in California. We don't have an expectation, and our role here is simply that we volunteered to fulfill a need that the Board of Trustees identified. And that's what we've completed. And we were invited here today to talk about the draft.
And I thank you for coming. Okay, yeah, I guess, well, then maybe, Donna, we have to find a way, in my view, to just make it clear that we want to have an important role in this as the people that would ultimately have to implement it and then manage it over time. Alex, did you want to make do we have any other questions? And then we'll go to comments and perhaps a motion.
And it is, we are drawing a little short on time.
Okay, Alex?
I don't have any questions.
No comments.
Okay, comments. I think the court has already spoken on this very topic, so I'm a little confused as far as what we're trying to do here. And so, and for some of the members here, and this is a little bit of a background and context for you, I think back in October 2020, the court approved what is now known as the Rule 9.49, and we obviously called that as the PLP, and the PLP was originally intended to sunset by mid-2022. Then I think mid last year in May, the court extended the program by 7 months until the end of the year. And right before it was set to terminate in November 2022, the State Bar staff provided several recommendations to the Board of Trustees, among which there were 5 options. And for the committee's ease of reference, these 5 options, if I recall correctly, were extend the program by 1 year. That's the first option. Second option is extend the program by 3 years. Second option. Third option is to develop a pilot supervised practice pathway to licensure for those who qualified. That's a third option. Fourth option is develop a permanent alternative status beginning in 2025. That's the fourth one. And lastly, if I remember correctly, the fifth option was to allow participants to take the one-day attorney's exam instead of a full day bar exam. And so what was intriguing about these options is that the recommendation to develop a pilot supervised practice pathway to licensure was actually put before the court in December last year. The very same program, if not substantially similar in substance, that is now before the committee today. That program would have the State Bar develop for the Supreme Court a supervised practice pathway to licensure for a small cohort of applicants. And if I remember correctly, during the November board meeting, discussed these options. 3 of the members of the working group, Ms. Jackie Gardina of the Santa Clara University, and Ms. Mylene Spencer of UC Law School, as well as Ms. Susan Bachman of Loyola, all again expressed support for this supervised practice pathway to licensure. And so at the end of that program, the board voted, right, to recommend the 1-year extension. And perhaps I think this is where Jackie and I may disagree, because I think earlier at the beginning she said the board pushed forward all the recommendations, but if I recall correctly, from at least from the minutes, the board adopted only the first option, but then asked the court to adopt at least one of the other 4 options. But otherwise, my understanding is the board has never adopted anything other than first option, which is to extend the program by 1 year. So then came December 2022. What happened there was the court, reviewed all 5 options, pushed forward by the State Bar and the board, and issued an order. And in that order, the court granted a 3-year extension to the program. Now, what was telling about the court's order was that the justices specifically added a new provision to 9.49a. And for those who don't have it in front of you, that provision says verbatim, for 2020 law school graduates who have not received their passing score on the California bar exam, but have otherwise satisfied all the other requirements for the PLP before May 2023, that program will sunset later in December 2025. This very specific limitation is very important for our discussion today. It's important because it tells us the court's view in plain sight. And the court, armed with those 5 options by the State Bar and the Board of Trustees, could have selected the option to develop pilot program, which again was labeled as option 3 that I mentioned earlier, which is now being reintroduced by the working group. It chose not to do that. The court also could have chosen to adopt the option of developing a permanent program starting in 2025, which again, I think I previously labeled as option number 4. It didn't do so. And then remember, back in May of 2022, the court could have made the program permanent instead of simply extending the program by 7 months. Again, it didn't do that. So just looking at the history and just judging by what the court has done or did not do, it appears to me that the court has already spoken on this very topic. Now, there is a saying that words are not spoken, words that are not spoken are so much more powerful than the words that are not spoken in unbelief. And I think we, as a committee that serves the Supreme Court, just need to make sure that we're not ringing the same bell that has already been rung. So with that, I just want to go into the substance of some of the key issues that seem to be set aside. The one really critical concern that I have is the optic of this proposal. Now, whether we agree, whether me or the working group agree that the bar exam is a proper way to measure minimum competency, there is little doubt. And I do believe we can all mutually agree, at least within the committee itself, the bar exam functions to keep law schools accountable for the education standard. Now, just a few years ago, quite a few ABA schools were cited for the low bar passage rate, from Thomas Jefferson to Cooley. Now, instead of relaxing Standard 316, this is the ABA acronym, Standard 316, which governs the bar passage standard, the ABA doubled down on keeping these schools accountable by now requiring all these schools to demonstrate that at least 75% of the students will pass the bar within the first 2 years of getting a diploma. And to quote, and I'm quoting the managing director of ABA Law School Accreditation, and he said, most students go to law school to become lawyers. Becoming a lawyer requires passing the bar exam. How well a school graduates perform on the bar exam is a very important accreditation tool to assess the school's program of legal education. Yet this proposal offers nothing to assess whether these schools have actually met the standard of teaching. And maybe I overlooked it, but I have literally plowed through the entire proposal. I just don't see anywhere that says, all right, these are the standards these schools have to meet as part of this capstone fulfilled program. I just don't see it. Now, let's just fast forward. And I think this is the key issue that was brought up by Bethany. And thank you, Bethany. And the question she raised is very simple. where are these applicants going to find their legal work? It's no longer news. And I'm not sure why people would even advocate otherwise, that law firms are laying off associates across the country in this economy. There is nothing in the report that says the working group has studied the impact of the current and future job market. So we can assume, and I can never assume, that every applicant would be able to find a legal position. And the reality is that not everyone will find one, especially in this contracting economy. And I'm disappointed because not once have I heard the recognition about this fact. If anything, I felt that this issue was set aside with nothing but optimism. And who will suffer the most in a tight market where everyone is vying for the limited positions available? The ones who would suffer most would be those from the underserved communities who lack the funding, the resource, the knowledge, and the connection to find a legal job. And in relation to that, the proposal requires every applicant to work 700 to 1,000 hours, which translates into, for those who just want me to do the quick math, it's about 17 to 25 weeks, which are far more than 8 to 10 weeks that applicants typically spend to study for the bar exam. But also, this report assumes that not only would the applicant get paid for the legal work, the pay would be high enough to justify quitting his or her day job. Now, I'm not sure what the state bar has to force supervisors to pay at the level required. And from what the BRC had studied from the Law Society of Ontario, applicants are more, not less, than likely to be underpaid. It makes sense because of the inherent power imbalance between applicants and supervisors. Applicants would be willing to forego pay in the macro market where there's a strong demand for work, but limited positions available, such as what we have here in the legal industry. And if that holds, it is almost certain the bar applicants will not be able to treat this legal work as the primary day job that pays the bills or feeds the family. And remember, not everyone enrolled in our law school wants to work in the legal market, which is one reason why our California accredited and accredited schools are so unique in that aspect. And so if an applicant doesn't want to work in a law firm or public defender's office or legal aid, this proposal would effectively force those populations of applicants to take two jobs, meaning they'll be forced to work less at the day job to accommodate the legal one and receive less pay for 46 months, or in the alternative, work 8 hours at the day job to keep the pay, but work only a few hours at the legal job, which would certainly prolong their completion of the program far more than 4 to 6 months that are just estimated at a minimum. And that assumes that they have the able body to take on two jobs. I personally can never take two jobs, but this is why it's so problematic. And again, if this holds true that it would take upward of many months, more than 6 months, upward of a year or more to complete this 700 to 1,000 hour requirement, we're going to see applicants from different class years fighting for the same limited positions, which all but guarantee that we have a large pool of applicants not being able to find a job for many months or even years. The report doesn't tell me any backup plan. What if we can't have, what if we don't have enough positions? What are we going to do with those spillover applicants? Nothing like that was ever mentioned. But the one key issue that is most concerning is that the report does not mention that at least 26, I repeat, 26 California Bar Associations have already questioned the integrity, reliability, and effectivity of this program. With no support from the Bar Association across California, and perhaps that may be what the working group system mentioned about the legal aid. But if we have no support from the Bar Associations across California and their members not serving as supervisors, and of course, and I think Leah just touched upon that, where the fees is essentially going to be shifted onto attorneys who will now pay more every year to fund the program. Well, one could argue the program would be dead on arrival, right? If not, what would already be the very few seats available in a contracting economy would definitely become far fewer, which would amplify our existing DEI issues by several magnitudes. And so you can put all the applicants in the public service sector, but the reality is that many applicants want a high-paying job. So you will have a spillover effect where once all the positions are filled in the public sector, well, we're going to see an ever increasing population of applicants not being able to find a job. And then what? How are we going to solve the problem? And just lastly, the proposal, what really bugs me is there is no plan to terminate this program if it goes very. There is nothing in place that would ensure public protection and to protect those applicants who are now in the pipeline that can't find jobs. So those are my comments, and I'll be happy to hear from any other committee members who want to, address some of my concerns.
And I would love to have an opportunity to respond. I realize that we're almost out of time, but if the CBE is going to vote on a motion, I would like to speak to some of what Alex has stated. I don't know if I can speak to all of it, but one, I think his statement about the Supreme Court's decision overstates what can be taken from it. First, the BRC was still working at the time that that decision was made. And they made the decision to extend it for 2 years, not just one. And it could be interpreted that they wanted the BRC to complete its work, not get ahead of the BRC, and decide to develop an alternative pathway until the BRC made its decision. So I think it can be interpreted more than one way. Two, this is an option for licensure, not a mandate. So it isn't necessary for every graduate of law school to actually assume or take this pathway. Many may, and many may have to choose the traditional bar exam. Third, I'm not sure how to respond to your idea that the bar exam is supposed to hold law schools accountable. The bar exam is there to protect the public. At least that's the theory. What I would like to have is an exam pathway that actually reflects the realities of practice. So what I'm being held accountable for is graduating skilled, competent, and ethical attorneys, not attorneys who are really good at standardized exams. So while you want to hold law schools accountable through a bar passage, I want to hold law schools accountable because of the skilled and competent attorneys they graduate who can actually show through work product that they meet the minimum level of competency necessary to serve clients. So while you and I differ dramatically on that, I remember from your dissent, you actually spoke to the potential of a pilot. So I would hope that the CBE would at least support exploration of this pathway, even if it lacks perfection, or even if we don't have all of the questions answered yet. What you're doing is shutting down a potential pathway simply because we don't know all of the answers yet.
To add to Jackie's comments, I would just also respond that I disagree with some of Alex's characterizations and agree that there are multiple interpretations of some of these events. Most importantly, there are multiple interpretations of what holds law schools accountable. Alex's comments have been addressed to a bar exam pass rate as one ABA rule. That is one rule. The ABA has many, many volumes of rules that hold law schools accountable. And again, the examination is about public protection, much more so than law school accountability. The ABA does do that for my school. The state bar does that for California accredited schools. But I would also add just the general point that the current exam, the traditional exam that is in place today, addresses none of the economic concerns raised by Alex about job availability, economic drivers, and whether or not there are enough positions for those who become licensed. I don't believe that we have ever in California limited our licensing to the availability of attorney spots that there are. Instead, we license people who have proven their ability to have minimum competency as established either by the traditional exam or by what we propose as the portfolio bar examination instead of a proxy, a direct assessment of those skills and knowledge, and that we would not in any way limit that based on economic drivers and availability of the job market, which is a control far beyond the examination in any form, whether it be portfolio or traditional.
Okay, I'm going to, law school folks, I'm going to have you just stand back, and because we're at the point where we've had all our questions asked, and this is in the interest of time. And unless the member of the committee addressed a question to you,
Ursula does have her hand raised. Paul.
we are now at the point. Okay, well, I'll get there in a minute, but we're at the point where we're discussing among ourselves and deliberating what we might want to do. So we'd prefer not to have you be a part of the deliberations because that would be inappropriate. Ashley?
Yeah, I think that honestly, a lot of the thinking that goes into the bar, and especially if you look at some of the letters that were submitted by bar associations, are centered around maintenance of what's, in my mind, a hazing program. I think that it really just prioritizes one method of thinking that doesn't necessarily apply to every student. I think having multiple options with a traditional bar as a background option for those that do well in standardized testing allows us to encompass all of the skill sets that make a good attorney, and also gives people the opportunity to choose what's best for them. One of the other points we talked about is this idea of people not wanting to work in law firms or in legal aid and things like that, and then being restricted from this program, but they would be self-restricting out of that program. So I'm a little confused about what that argument is, because if they're wanting to work in government, they wouldn't take the bar unless it was something that required a legal license to practice within. So either way, they would be choosing not to take a bar or the pathway, or they would be taking the bar or the pathway and then practicing law in a field that requires that. Otherwise, if you're going into like politics, government practice that doesn't require actual legal practice, my thought process is that it's all the same. Ultimately, you have the same decision. You can choose to take the exam, you can choose to take the pathway, and either way, it's not restricting your ability to do either. I also think that when we're looking at job access and this idea of flooding the system right now, I mean, from all I've heard as a new attorney, I'm only in my second year now, there's a desperate need for attorneys. My firm has been desperate for attorneys. Many firms have been desperate for attorneys, and even post-bar attorneys or post-bar law clerks would benefit many of the markets that we're looking at trying to assist in those legal deserts that Kareem was talking about. So I personally think that at minimum, this is something that we should push forward. And ultimately, I think that if the Supreme Court doesn't want it, I think that should be up to them. But I think as far as us, I don't see that many drawbacks to the actual implementation of this kind of a program, at least as far as to explore what it looks like and determine whether or not it could actually help our students instead of hurting them by requiring them to memorize rote information that doesn't actually apply to their practice.
Okay, anyone else? Okay, seeing none, Larry.
Yeah, I have a question on process. So do we have to make a motion to today, or what are we being asked
Staff
to do?
Two alternative motions I can show us in a minute. One.
Sorry, you cut out. Sorry.
Yeah, you cut out.
I think he was saying that we developed
make a recommendation. Am I cutting out? I think I'm having a little bit of. Okay.
Go ahead.
Yeah, you guys cut out on me occasionally. Larry, the Board of Trustees is going to consider sending this forward to the Supreme Court later this month. So this is our one shot to make a recommendation to them prior to their doing that.
And this is not that we're adopting the alternative pathway. It's just to continue to explore it, correct?
Well, I mean, that's a little unclear to me. My concern is the way things seem to work is that once something gets momentum, it can be hard to dial it back if it turns out it wasn't particularly well taken. And so one of my concerns would be that we clearly label this as an experiment to be reviewed later before it becomes something permanent. And my other concern that I talked about earlier is that we be more involved in the process of reviewing it and the results than we have been with the VRC. Does that answer your question?
Yeah, and so the one way to test it is that pilot project with the 100 people, correct?
Right. Yes.
Okay.
Kareem, you had your hand up?
Oh, thank you, Mr. Chair. No, you answered my question there. I was wondering if the motion included a pilot project, and so that answered the question. Thank you.
Okay, well, we'll put it up on the screen in a minute. I think I said my piece. Anyone else want to say anything before we look at alternative motions? Audrey?
I don't see any other hands. Are you asking if I want to say anything?
No, could you put it up?
Don, you want me to put it up or you want? Wait, she's saying, hang on. She is making a modification in what I shared earlier, Paul.
Okay.
So just 1 second. Okay, Donna's sharing her screen. Donna, you're on mute. Maybe you know that.
Maybe you could zoom in a little, Donna. Yeah, I'm watching it on big TV. That's great. Thanks.
Do you want me to read it? Oh, okay. Go ahead, Donna.
So taking some, I've been listening to what you've been saying. And so what I've got here says, move that the Board of Trustees be informed of the Committee of Bar Examiner support for further exploring the portfolio bar exam proposal drafted by the Alternative Pathway Working Group, and move that the Committee of Bar Examiners recommends that the Board of Trustees forward the portfolio bar exam proposal to the Supreme Court with a recommendation that the Supreme Court authorize further exploration of a portfolio bar exam, and move that the Committee of Bar Examiners recommends that the Board of Trustees include, as part of that recommendation, that the Committee of Bar Examiners participate meaningfully in the exploration and development of the portfolio bar exam.
I'll make that motion.
I'll second.
Who was the second? Ashley, was that you?
It was Ashley.
Mm-hmm. Yep.
Okay. Any further discussion?
Got a question, Chair.
Just speak up so I can see if anyone's raised their hand. Just speak up if you have.
It's Alex.
Chair.
Alex.
Go ahead, Alex.
Yeah, at the very end, I think the last provision, it says meaningfully the exploration and development, but I thought for the previous two, we're only exploring and now we're developing, which is different from exploring, because I think development now really goes into the detail as far as adopting the bar exam. Maybe I'm just reading in too much, but is there a specific reason why we're including development in the last provision?
No, that's a good point. What do you think, Donna? You wrote those words to.
Yeah, so I'm sorry, I'm just finding my tools here.
Well, that last paragraph is more about the role of the CBE rather than, that's what it's saying. That's all.
Yeah, the second one has exploration and the third one doesn't. So the second one assumes what the operative is.
Yeah, that's one good drafting point that hopefully they will test for, is that people are, what is this called? Parallel
construction, but you have to forgive me. I was doing this as you all were talking and at the very last second. So I think we came pretty close.
And you already passed the bar exam anyway, right?
Yes, but it was 30 years ago.
Okay. Okay, did the maker and the second agree with that change?
Yeah, I do.
Yes.
Okay. Anything further? Okay, Devin, let's take a roll call vote.
Dr. Bolton?
Yes.
Robert Brody? Dr. Cow?
No.
Alex Chan,
No.
Jim Epting, Kareem Gangora,
Yes.
Dolores Heisinger, Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn,
No.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Vince Reyes, David Torres, Paul Kramer,
Yes.
with 6 yeses and 3 nos, the motion passes.
Okay, thank you, everyone. That concludes our business for today. So we will adjourn our meeting. Have a happy Labor Day.
Thank you. Thank you all for hanging in there with the meeting. Appreciate it. Thank you.
Thank you all.